May I please, madam? My lord, I would like to mention item number 11. I'm for the petitioner. I'm so personal difficulty today, my lord. May I pray, my lord, this may be listed on 24th, my lord, of this month.
Item number 11.
11, my
It's
lord.
a criminal petition.
Yes, my lord, criminal petition.
You have some personal difficulty.
Yes, today, my lord.
You are praying for 24th,
24th, my lord.
4th of March.
24th of March. This
Ground to live due to personal difficulty.
just, my lord, interim order is there, my lord.
Interim order will take. Interim be continued to the next date of the state.
Obliged.
My lord, I beg to mention item number 8, my lord. But I have obtained.
You are for the petitioner or the respondent?
Yes, my lord, I am for respondent, my lord.
Who is the your for petitioner side? Interim order is with the
2 weeks.
consent of the petitioner side, the learned counsel for the respondent bid for an adjournment. Prayer allowed. And for the appeal and loss. We contain or report about this. Now see, this is the criminal appeal and person isn't behind the, jail. Because it is a case of 2019, in fact. You're for the appellant. Yeah. And the respondent also, one private respondent is there, I think. Considering the consider after 1 week will do, after 1 week, list after 2 weeks. 2 weeks, after 2 weeks, you do proceed with the hearing, huh? Because it is a case of 2019, in fact. After 2 weeks. Okay.
If I may, my lord, I beg to mention item number 4 and 5.
4 and 5.
Yes, my lord. My lord, the SPP has informed me that it's out of station, my lord.
Who?
The SPP, Mr. Siring.
Mr. Seri.
Yes, he's for the SIT, my lord. Therefore, my lord, I pray that
Sering is now being as a special PP SIT.
SIT, my lord. So he's out of station and he has prayed that he will be back tomorrow. Then can this matter be fixed on Thursday, my lord?
No, Thursday not at all. Monday.
Monday.
Monday or Tuesday. Thursday not at all possible.
Actually, my lord, there was our prayer for interim was also there, my lord.
Thursday not at all possible. Not at all. Maybe on Monday, either Monday or Tuesday. At best.
My lord, can it be then it won't be possible to hear in the absence of the PP also, my lord, that our interim prayer?
No, how can it?
That's
Can it? That is also it is a under the case of Multiple SIT, specifically
Yes.
is there. So it should be
that is
maybe after Monday.
Monday, madam.
Monday will be. Monday.
D. Gogay, standing counsel for Assam Forest Department. He wants to file further affidavit on opposition. So some time may be given.
Item number 18.
Yes, Your Honor.
So you are for the respondent.
2. Respondent
Respondent
number.
number 2. The SC Forest.
Yes, Your Honor.
SC Forest. On behalf of so respondent number 2. The standing counsel of the Forest Department, the learned counsel for the learned counsel had paid for an adjournment, stating that 2 weeks time is
Lordship,
written objection.
fixed date can be given.
You want to file your objection?
Yes, Your Lordship.
Objection.
7th of April.
7th of April.
Yes, Your Lordship.
You want to fix date?
Yes, Your Lordship.
Okay. 7th of April.
Oblige, Your Lordship.
May I please, Your Lordship? Lordship, I'm appearing on behalf of Senior Advocate Move Burton. I'm here to mention item number 25 for adjournment, Lordship.
The party is not available today.
Not available, Lordship. He is out of station, Lordship.
Senior counsel out of station and in both party. It's after 2 weeks.
May I, my lord? My lord, I beg to mention item number 22, my lord. I'm for the respondent, my lord.
Hmm. Then you're for the respondent.
Yes,
So
sir.
why you need an adjournment?
My lord, actually, I have to file the affidavit, so I need more time to file the.
Have you taken consent with the other from the other
Yeah,
side?
yes, sir.
You are for the petitioner side. Same political.
Yes. Kindly it may be adjourned. Maybe listed after 3 weeks.
For the petitioner or?
I'm for the respondent, private respondent number 3 and 4.
Appearing person, I
Yes.
He is available here.
He has contacted us telephonically this morning that he will not be able to appear today.
Otherwise, you have made a contact with him.
Yes, yes.
You are for the respondent.
Yes, respondent number 3 and 4. Private respondent.
Your good name?
M. Kambo.
Mr. M. Khamon, the counsel for the appearing for the respondent number 3 and 4.
Yes.
Wait for adjournment with the consent of the petitioner side. Was there any interim here? Do you know?
Pardon?
Interim was there any?
I think interim was there for petitioner.
No, we are not in a position to say it. Item number 10 related. List after 3 weeks going on. Let us see in regards to whether there is any interim. Interim order be continued till next. Was there was an interim order.
I've taken consent from the other side also.
It's a matter.
Yes.
You are for the
I'm for the-
petitioner appellant.
I'm for the appeal party.
Huh?
The opposite side. Opposite party.
Opposite
Respondent.
name is not reflected. I don't
Yes,
know.
I have submitted my Vakalatnam also.
You are for 21, na?
Yes, also 21.
So you are for the respondent.
Yes, Lordship.
Name is not reflected.
I have already submitted my Vakalatnam.
Okay, you are Mr.
This side.
Okay. 21 only for heard Mr. D. Sekia, the learned counsel for the respondent. And you need an adjournment.
Lordship.
You need adjournment. today.
Lordship.
And with the consent of the other side, it paid for an adjournment. However, it is seen that the name of Mr. Sekia is not reflected in the cause list. Registry is accordingly directed to reflect the name of Mr. Sekia on the next date of listing. That will be adjourned, list accordingly after 3 weeks.
Lordship.
After 3 weeks.
Obliged.
Snappy. My lord, I have challenged the order dated 15/1/2025 passed by the trial court, Your Honor. rejecting my application under order 7 to 11. The impugn
Where
order
is
is
the order?
page number
Impugn order?
41.
Impugn order is at
Page number 41.
51.
Page number 41 is the impugn order.
This is the impugn order.
This one, 15/1/25.
Your prayer for what was your prayer?
My prayer is this, Your Honor. I prayed before the honorable trial court that the plant is barred by law of limitation. And in para number 5 of the
Or your petition under order 7 rule 11
yes,
was
sir, that petition was rejected.
rejected.
Your Lordship. So, Your Lordship, in para number 5 of the impugn order, the learned court observed that it is submitted by the learned counsel for the defendant that case of the plaintiff is on the basis of MAU dated 29/9/2018, Your Lordship, and post-date check issued on the date of execution of the MOU. So, the entire case, as per averment of the was based on MOU executed on 29/9/2018, and suit was filed on 30/6/2023 after expiry of more than 5 years. So, my lord, the suit was
36.
clearly barred by limitation. Therefore, it is submitted that if period is to be counted from the day of execution of MOU and the pre and post dated check, the incident should be hit by the law of limitation. This was my submission. Now, thereafter, the learned counsel for the plaintiff also submitted before the trial court in para number 6. The learned counsel has submitted that incident should is not hit by law of limitation as liability of the defendant to pay the plaintiff does not arise from day on when MOU was executed, along with the post-dated check, but from the day when the defendant refused to pay the plaintiff and denied his liability. So, it was submitted by the learned counsel for the plaintiff. The cause of action arose when defendant refused to pay. But on perusal of the plan, it is nowhere mentioned in the plan when defendant refused to pay. There is no mention of that. Para number 23, page number 23, my lord, may kindly have a look on page number 23, which is the cause of action para of the cause of action for the suit arose first on 29/9/2019. There is a date of execution of MOU, when the memorandum of understanding for the payment of outstanding amount was signed between the parties, and subsequently arose on 31/2020, 26/9/22, 19/10/22, when defendant was represented by counsel, knowing that defendant is civilly liable. The cause of continuously arose on subsequent date of hearing of CR case so and so, and further arose on so and so date when the Honorable Court of Chief Judicial Magistrate has declared the plaintiff as proclaimed absconder. So, the cause of action was projected as the date on 31/2020, 26/9/22. These are the dates, Your Lordship, when there was a parallel proceeding of NI case, when the parallel proceeding was going on. So, filing of the parallel proceeding of NI case, that is on 31/2020, was the date when NI case was filed. So, plaintiff has projected filing of NI case as the cause of action. My lord, the cause of action is a bundle of facts and not the bundle of judicial orders. So, projection plaintiff, the bundle of judicial orders as the cause of action cannot give a second bite to cherry on, Your Lordship, because the cause of action, when it is settled law, the cause of action is the bundle of facts, not the orders passed by the judicial court. So, these dates cannot be taken as excuse for extending the period of limitation. And it is well settled law, my lord, that suit for recovery of money is 3 years from the day when cause of action arises. And here in this case, there is no correspondence after 29/9/2018. But plaintiff and defendant, no correspondence was made between them. There is no date mentioned in entire plan.
When this 31/2020, 26
31/2022. These are the date of filing of NI case. These are the date when NI case was filed. And that NI case has also been passed. That is a separate issue. their NI case has already been passed. So the plaintiff has projected filing of NI case as the cause of action, and this is not law, Lordship.
But in pursuant to that memo of understanding, suppose I
I'm not
mean,
getting it.
parties on the strength of that memo of understanding, MOU, was there any this transaction of money and all? So on that basis, most probably those NI cases were filed,
Yes.
claiming that these are the things and all.
Yes.
So initially, before approaching the civil forum, most probably they approached the civil criminal court with an NI case.
Yes.
So that's how they brought these dates as an the cause of actions. That may be
Pardon,
those dates wherein the NI case was filed in pursuant to that memo of understanding, in fact, that those cases
yes,
or
yes.
the dates were brought by them
Yes.
as an the cause of action, because prior to approaching this the forum of the civil forum, they most probably approached the learned court below with an NI case.
Yes,
That
that-
may be because
that-
the
that
check
is-
was signed, in fact.
Lordship, filing of NI case is a separate issue, completely independent process.
Separate issue means, since this is those cause of action arose out of that memo of understanding, in fact.
Yes, only
Yes,
in the plaint also. In the plaint also.
Mohammed.
Lordship, the further proceeding may be issued, and the notice may be issued to the respondent.
Stay cannot be here now. Just let us have here. What is the sales at present? Now, tell us.
WS has been filed,
Hmm.
and the case is at the stage of necessary order.
Necessary order.
This is the summary procedure. It was the summary procedure, and I had filed a leave petition to allow me to defend the suit. And the necessary, or the court has takes the matter for passing necessary order on my leave petition.
See.
Lordship, there are various judgment of the Honorable Supreme Court, Lordship, that the parallel proceeding.
But this even if suppose your order 7 rule 11 petition was dismissed, but in that case also you can raise this issue as a preliminary issue also. You will get the chance. Even after filing of your WS, that can be raised because you have brought this mainly issue that is about by limitation.
Lordship, this has already been decided. This has already been decided. When I filed the petition, order 7 rule 11, petition was filed.
That issue was decided.
The court has finally decided the matter. And if I challenge the matter, then it will attend the final matter.
You are Mr. D.K. Gupta?
Yes.
Heard Mr. D.K. Gupta, the learned counsel for the petition. This is an application under Article 227 of the Constitution of India against the Union Order dated 15/01/2025, passed by the learned Civil Judge Senior Division, Lower Dipang Valley District in Manisut number 02 of the 2023, whereby the application number 115 of 2023 dated 6/11/2023, filed by the present petitioner under Order 7 Rule 11, CPC was rejected. It is submitted by Mr. Gupta that from the plain reading of the FIR, it is seen that the cause of action is on 29/9/2019, 29/9/2019, when the MOU was signed by the parties, and after expiry of more than how many?
5 years.
5 years, the the respondent approached the learned court below or learned civil court for with a money suit number 302 so. But accordingly, the petitioner also filed an application before the learned trial court below for rejection of the plaint due to non-maintainability on the ground of limitation under Order 7, Rule 11 CPC, but that has been rejected by the court by the order dated 15/1/2025. Next one. Considering the submission made by Mr. Gupta, the present petition is admitted. Issue notice to the respondent to register AD and process. Also call for the scan copy of the TCR. However, the prayer for stay may be considered on the next date of listing, as I do not find it name date of listing. May be considered. At this stage, I am not considering your interim prayer for stay because
Lordship,
it is only on the
I don't mind.
necessary order fixed.
one submission was left out. And, Article 26 is clearly stated that when the accounts are stated in writing signed by the defendant or his duly authorized in his behalf, unless where debt is by simultaneous agreement in writing signed as aforesaid, made payable at a future date, then when that time arrives. So because the specifically this specific provision is there, the cause of action starts from the day when the when acknowledgement of liability was acknowledged by the defendant. This is the clear day, not from any other day. So MOU is the best document.
That's why you have approached this court with that plea. So we'll see to it. Now take steps for the respondent. The matter may be heard and decided finally on the next date of listing. Even we'll try. If the lower court to receipt, and by the time we have already furnished the this copy of order, etc. here, 10 copies also here.
Yes,
So
everything.
it may not be difficult also on our part to dispose of the matter. So we are listing it after 3 weeks. Do you want any fixed date? You have come from where?
4 weeks will be granted.
4 weeks.
In the month
List
of
after
April.
4 weeks. You take 6 days for
Proposal PS case number 24 of the 75. In fact, also this is a second bail application by the applicant for this on the court. Also, it may kindly come to page number 17, 18. This is
page
20,
7.
an express bail also. This was the last order. This is the order of my last bail application. So during the pendency of this bail application, also, the applicant has received a notice from the IO. Accordingly, he went before the IO and his statement was recorded. After the lawsuit, again on this 7/3/25, I have received another notice also. So
7/3.
yes, also. The page number 19. So accordingly, a fresh apprehension will be arising by the applicant also. So hence before this on the so I'm ready to cooperate with the investigation.
But in earlier occasion, you appeared and you gave your statement also.
Yes, also. Again, this press notice was issued. So this press apprehension is issued. So I'm directed to appear before the IO on 19 of March.
Yes.
Yes, Your Lordship. Yes, earlier he has granted bail and basing on his cooperation. Earlier, interim protection was there. However, Your Lordship, in compliance of the notice, he has appeared and given the statement. So this honorable court find that there is no any apprehension. It was rendered in process. However, subsequently, Your Lordship, the press notice issued to him. So there exists apprehension. So he may be protected.
Heard Mr. D. Sekre, the learned counsel for the petition, and also heard Mr. T. the learned additional PP appearing on behalf of state respondent. This is an application and section in connection with it. Next, it is submitted by Mr. Sekia that this is second bail application, and the earlier bail application was disposed as rendered as considered to be infructuous on the infructuous full stop. Earlier, the the notice is issued by the IO him to appear on 19/3/2025, and thus there is an apprehension of being arrested in connection with this case, and hence the petitioner needs some interim protection so that he can appear before the IO and can cooperate in the investigation of this case. Next para, Mr. Ete, the learned additional PP submitted in this regard that it is a fact that the earlier bail application was disposed of as considered to be infructuous after a recording of his statement by the IO as he appeared in pursuant to as he appeared after receiving notice under section 35 of BNSS. But thereafter the press issuance of the notice on 7/3/2025. But there may be an apprehension of arrest as subsequent notice was issued on 7/3/2025. However, he insisted to call for the case diary to know the actual fact of the case. Next para, considering the entire facts and circumstances of this case, I find it appropriate to provide with the interim protection for the one. Okay, will be under interim protection, appear before the IO, cooperate in the investigation, and we are calling for the case diary. When it can be fixed?
Your Lordship, the notice date is on 19th of March.
Yes, 19.
Yes, he can appear on 19 itself, Your Lordship. After
Yes.
19th, Your Lordship. Maybe on Your Lordship, 24, Your Lordship. On Monday.
24, yes.
24, yes.
I'm listing it on 20.
Yes, obliged, Your Lordship. But
It's a case of POXO.
Yes, madam. But madam, this peculiar case where this wife has filed the complaint, madam. No, madam. In the meantime, when I was there, madam, and basically DPR was put forward by the Arunachal Pradesh Consumer Cooperative Federation, madam, APCCF, then administrator, saying that they need loan, madam. The loan was, the proposal was for 1,312 crores, madam. That is 13 crores. That loan was sought for by the APCCF. Now, in the meeting of the consultative meeting, madam, and there were many members, madam, the committee decided that 500 lakhs, madam, that is, madam, 5 crores can be given as a loan to APCCF. Since the APCCF is a member of the bank, madam, and it's more or less a government organization also. So the committee decided that, and that was for a specific purpose, madam, for procuring the PDS items, madam, rice, sugar, and things like that, madam, or medicine, etc., madam. Now, after that loan was sanctioned, madam, the then administrator, madam, he used those money instead of procuring the for payment of bills, including to the firms owned by his wife, madam. My role is only to the extent of giving loan. So, my lord, I will just take your lordship to some documents, my lord, in the charge sheet itself. And my lord, what happened, my lord, in the year, and in addition to this, my lord, a complaint was lodged, my lord, against me, my lord, the petitioner, my lord, who was at that time the administrator of the Apex Bank, my lord, saying that I have been politically appointed and I have given away loan of amounting to rupees 71 crores, my lord. And subsequently, my lord, in the year 2015, my lord, a PIL was filed, my lord, against the administrator of the Consumer Federation, my lord, saying that the Apex Bank has given a loan, and but that person, the administrator of the Consumer Federation, he has misused that money, my lord. And when that PIL was pending, my lord, under the basically under the direction of this honorable court, the subsequent FIR was registered, my lord, and both were amalgamated. But the charge sheet has been filed in the 9 of 2016. ma'am. My lord, if your lordship will come to page 53, my lord. There are, my lord, two administrators involved, my lord. One is for the bank and another is for the Consumer Federation, my lord. This is the DPR, my lord, by the proposal for enhancement of case credit limit, my lord. My lord, down below, my lord, will see, my lord, submitted, it is submitted to Arunachal Pradesh Cooperative 57. 57. This serial number, scope of the works, Malod is there, madam. Scope of works, one is the procurement of medicine. Serial number 2 is public distribution rice, madam, PDS rice. Serial number 3 is public distribution sugar, madam. Number 4 is for general items such as grocery and electrical, etc. madam. And proposed is 1312 lakhs, madam. 13 crores 12 lakhs, madam. And next page, madam. 58, madam. Page 58, madam. And in lieu of the loan, my lord, what was the security offered, my lord? This is the serial number 5, it's collateral security offered, my lord. PDS bills, mortgage, land, hypothecation of the so and so. It amounts to that offered by the federation amounts to around 34 crores, my lord. Oh, if next page, my lord, 59, my lord, it is the documents, my lord, mortgage certificate, etc., my lord, which was submitted by the federation, my lord. Now, if you also would come to page 68, my lord. 59 onwards is the documents and hypothecation, my collateral that was submitted. My lord. These minutes of the 38th advisory committee meeting of Arunachal Pradesh State Cooperative Apex Bank Limited. The 30th meeting of the advisory committee of Arunachal Pradesh State Cooperative Apex Bank Limited was held in the office chamber of so and so, who is the petitioner here, my lord, on 6th September 2013 at so and so, and serial number 1, my lord, I am the petitioner. I was the chairman, and my lord will see there's a manager, general manager of the NABARD is there from various departments, and all total, my lord, there were 9 persons, my lord, in the committee. My lord. They decided, the committee decided at page 70, my lord, next page, my lord, at agenda item number 12, my lord, to consider the CC loan proposal of APCCF, my lord, that is the Consumer Cooperative Federation, my lord, for buffer stocking. The Arunachal Pradesh Cooperative Consumer Federation applied for consideration of case credit limit of 900 lakhs for buffer stocking of medicine, PDS rice, levy, sugar, grocery, and electrical items to be supplied to the various districts of Consumer Cooperative Federation Limited, and some collateral security amounting to so and so, pending with department so and so, and 1312 lakhs of land and building in Itanagar.
As per you, there is any misappropriation or corruption, suppose anything,
No,
that has
no.
been done by the APCCF.
APCCF, my lord. It is, but in the charge sheet also, my lord. It's there, my lord. Will see just I was just reading this because by this, my lord, the committee decided that since there is urgency of timely delivery of these items also, my lord, that 500 lakhs, my lord, it was given. And just, I'm sorry, my lord, since I have a interim prayer, my lord, I'm burdening your lordship, my lord. At page 73, my lord. To securities, my lord. So and so, my lord. Terms and conditions, everything is there, my lord. And subsequently, those that amount was given. Now, what happened, my lord? I will take your lordship to the charge sheet, my lord. What the investigation itself revealed, my lord. At page 43, my lord. 43, my lord. 43, my lord. I'll just read some paragraphs, my lord. Here and there. Though that 5 crore, my lord, was sanctioned for a specific purpose, my lord. Page 43, my lord. This is the charge sheet, my lord. On that is so and so, the 30th board meeting of the advisory committee of the AP State Cooperative Action Manual held and approved only rupees 500 lakh as cash credit limit for Arunachal Pradesh Consumer Limit as follows, madam. These are the items for which the loan was given, madam. For rice, medicine, grocery, and sugar, madam.
Okay, then what is the allegation now?
Yes, madam. Then subsequently, my lord will see at page 44, my lord. This is where the misuse has been done. If your lordship would come to, I will skip some paragraphs, my lord. The second last paragraph, as per, my lord. As per the loan application and detailed project report loan proposal prepared by the then administrator, APCCF, that is the Consumer Federation, my lord, and minutes of advisory committee meeting shows that the loan amount of rupees 5 crore was sanctioned for purchase of medicine, PDS item, electronic goods, etc. for enhancement of Federation business, but Sri so and so did not deposit the loan amount even in the account of APCCF Limited, but from that amount cleared the outstanding HTS bill by changing the purpose in contrary to so and so. Then next, my lord, the administrator of to see this table, my lord. How that person, my lord, the administrator of the federation, my lord. I am the bank, my lord. I gave the loan, my lord. Now, how that person misused, my lord? Serial number 1, my lord. My lord, notice the amount also, my lord. 5 crores we have given, my lord. Serial number 1 is Messrs. MMM Enterprise, my lord. Two checks that amount was given is 1 crore 96 lakhs, my lord. And second, that Consumer Federation has paid to one person, my lord, Messrs. So and so, for 99 lakhs something, my lord, almost 1 crore, my lord. And next page, my lord, serial number 3, my lord. Assam, Arunachal, so and so, 2 crores. Overall, the entire 5 crores has been used by this person, my lord. Now, say, subsequently, last one paragraph I will read, my lord, at page 45, my lord. 5 crore loan was given, my lord, see the table, my lord. It's almost 1 crore, just 3 or 4 lakhs is not there. Next page, my lord. Just down below, 3 so and so, the then administrator, APCCFL Naharlagan, intentionally utilized the loan amount, which was meant for purchase of PDS, non-PDS item for enhancement of Federation business, but clear the HTS BLs of so and so to his wife so and so, so and so, and so and so. Sri so and so had obtained the loan and cleared the HTS bill in clandestine way by concealing the fact from his office staff and also misleading the, this is the bank, Arunachal Pradesh State Cooperative Apex Bank, Limited, by placing the forced intent for procurement of medicine for 2 counters as Neris so and so, so and so. This is what the investigation also revealed. The 5 crore loans that I have given, the bank has given, that person, the Consumer Federation, his no evidence as such. Nothing to show, my lord. At the best, my lord, maybe, my lord, one allegation only is that I should have waited for the approval of the Register of Cooperative Society before disbursing the loan, my lord. But although we had sent those minutes, my lord, the reply did not come. And in fact, the reply came only after 2 months of the approval of the loan, my lord. But otherwise, nothing there, my lord. My lord knows, my lord, under section 409, that's criminal breach of trust, my lord, and the section 13(2), my lord, of the PC Act, my lord, it is similar, my lord, where the person who has been entrusted with the property utilizes it for his own purpose, my lord, dishonestly, my lord. And 13(2) of the PC Act, my lord, it also amounts to the disproportionate assets also. There is nothing there to show that, my lord. And 420, my lord, it talks about the dishonestly inducing the delivery of property to me, my lord. But it has not been there, my lord. Nothing, my lord. And surprisingly, my lord, if lordship would come to page 133, this is the charge, my lord. 133, my lord, the last page, my lord. 133 is the charge, my lord. So and so, my lord, accused number 1 is the then administrator of the Consumer Federation, my lord. And I am the accused number 2, my lord. Number 1, my lord, firstly, in the year 2014, both of you had criminal conspiracy in sanctioning and disbursing the different loan amounts, and thereby you have both committed an offense punishable under section so and so within my 2, my lord. Secondly, that both of you had fraudulently cheated the Arunachal Pradesh State Cooperative Bank, Apex Bank Limited, causing wrongful loss to the tune of rupees 71 crores, my lord. Where does this amount come from? Even the charges does not mention about any amount. It only talks about 5 crores, man, which the accused number 1 is misused, man. And thirdly, my lord, both of you being public have breached the trust by misusing the position and amount which were of benefit of public, and thereby you have committed an offense punishable under section 409, read with section 13(2) of the PC Act within my community. Accordingly, my lord, that charges have been framed. And other than this, my lord, we are raising the issue of the sanctity of the prosecution sanction also. But at this time, during this stage of motion, my lord, I'll not burden your lordship. But my lord knows that sanction also has to be given by the application of mind, and the person should not be under any pressure. Whereas, my lord, recalls that I have annexed, my lord, the prosecution sanction itself, the order has been passed in such a mechanical manner because of the pendency of the PIL, my lord. There was a pressure on the person, the authority, that prosecution sanction has to go in, and just mechanically it has been done, and it is in verbatim with the charge sheet of the police, my lord. Basically, that's my case, my lord, that there is nothing, my lord. If my brother can show, my lord, that there is anything in the charge sheet, my lord, showing that there is a money trail, I have used that property for myself, I have received any gain, and otherwise I did have any property disproportionate to my income, my lord, I will in fact withdraw this petition, my lord. There's nothing, my lord. So that's why, my lord, I'm praying, my lord, please let more notice be, and I'm praying for some protection also against the petitioner, man.
Yes.
Please, my lord, as far as the stay is concerned, my lord, I'll vehemently oppose for that, my lord. Because it pertains to the embezzlement of government money, my lord. In fact, my lord, 2 FIRs were filed, my lord. Earlier, there was an allegation of embezzlement of 71 crores, my lord. Subsequently, my lord, another FIR was filed for embezzlement of 5 crores.
In the first FIR, there was an 71.
71 crore 29 lakhs, something around
Whatever.
1045. Now, thereafter, there was an allegation of 5 crores. Now, since both the FIRs, they were from the same transaction, both the cases were amalgamated into one case. Now, the basic allegation here is that the accused number 1 and the accused number 2, both in connivance, has, the accused number 2, the present petitioner, he has sanctioned those amounts without the permission from the RCs, the Registered Corporate Society, so that it could facilitate the accused number 2, so that he could use those 5 crores for some other purpose, for his own personal benefit. And if Malak sees the charge sheet, Malak, there is a specific allegation against him. Malak turns to page 46.
Yes.
I'll just start from I'll just read it, Malak. It's Malak, annexure O after that. Page 46. Annexure O.
After annexure 4.
1, 2, 3, 4, 5, 6, line number 6, last. It is written in bold.
Yes.
That on dated so and so, only telling the present accused petitioner manner, and Minister of Tax Bank directed him to process the proposal for granting of loan of rupees 5 crore. He has directed MD, he is one of the witnesses of the Apex Bank, to process with the procedure of loan of 5 crores, now without waiting for the approval of the RCS, Minister of Corporate Society. Accordingly, an appraisal note was prepared by the General Manager Credit, stating that the proposal is exceeding the guidelines of Credit Monitoring Authority norms and the GM Credit a fresh note. Accordingly, a fresh note was prepared and put up by the GM through him for approval of rupees 5 crores of CC loan for APCC at Mahalagan, and the so and so has approved the same. Now, the basic allegation is that he has facilitated the accused number 1 in procurement of this 5 crores matter. And the accused, the other accused person, he has used this amount to pay the pending bills of his PDS bills. And those amounts were not deposited, were not used for procuring the medicines or the other items. They were deposited in the account in a firm owned by his wife's. There is a basic allegation. So, as far as the sanction is concerned, the provisional sanction is concerned, this is a matter of time, whether it was on duress or whether it was due to the PN, whether the authority has given a meaningful thought upon before giving the sanction. That is a matter of time, that will be taken up by the time. But at this stage, it is a very serious allegation, May I humbly pray, and oppose the stay, and the scanned copy of the CD may be called for.
Just so clearance, clarification, that when we say that Malot has gone through the page 45, that I have shown. In fact, the charge sheet itself says, police says, this person, the administrator of the Cooperative Federation, misled the bank. That is itself there.
Okay.
And just one more, regarding the NABARD and everything, at page 69, will come once again, just 1 second. Of course, we had sent to the RCS, but that reply never came. It came after 2 months, more than 2 months, In the meantime, we had disbursed, You will also see, one is the 2 is the general manager NABARD is also there in the committee, and serial number 5, if you will also see, They are saying the RCA instant crores, entire 5 crores, it is misused, my lord. The everything is there, my lord. The investigation officer itself, so the check is there, everything is there, my lord. That person misused and misled the bank, my lord. It is what the bank charge sheet also says, my lord. Nothing to show, my lord. That's all. All right.
Further, my lord, may I be given extra page so that I can take.
That's my lord. All problem.
Heard Mr. D'Souza, the learned counsel for the petition. And also heard Mr. Opata, the learned standing counsel SIC.
ACB, ma'am.
Itu ACB.
ACB.
ACB. This is an application under section so and so in connection with so and so. Next, Mr. Stoki, the learned counsel for the petitioner submitted in this regard. The present petitioner was working as a administrator of Apex Bank Limited at the time of during the period of during the relevant period, and it was the 5 crores loan of 5 crores was sanctioned in the name of the accused number 1, that is, who is he?
Tanya.
Tanga Baghe, my lord. Not in his name, my lord, but to the federation, my lord. Yes. And accused 1A1 was at page 133, my lord. 133.
Last page.
Of this said committee. It is further submitted by Mr. Suki that while sanctioning the loan amount, there was a board of meeting was held, and as per the mileage, wherein along with the present petitioner, the other the general manager of NABARD, as well as the deputy
DRCS, my lord.
DRCS
My lord.
was also present along with other
Other-
along with other members, wherein the minutes were taken, and as per the said committee resolution only, the loan of 5 crores were sanctioned. If I was submitted in the that is in the search sheet itself, it is mentioned as to how the loan was sanctioned. Loan of 5 crores was sanctioned to the administrator of that APCCI. Further, he submitted that there is no mention of whisper in the charge sheet regarding any misappropriation or the money that which was sanctioned by the bank of the present petitioner. He further submitted that as an administrator of the said Apex Bank, the only 5 crores was sanctioned in the favor of administrator APCCI, and that apart, the present petitioner is no way involved in the alleged offense. Even if any misappropriation was made, that may be by the accused number 1, who was discharging his duty as an administrator of APCCI and BPCCI. Further, he submitted that while sanctioning the, while granting sanction, while according sanction by the concerned authority, there was no application of mind, and only the sanction was accorded without any, in a very arbitrary manner, without applying any judicial mind. However, this issue may be raised subsequently. Full stop. Mr. He further submitted that the charge has already been framed against the present petitioner without his any involvement in the alleged offence, and accordingly he submitted that the further proceeding in respect of the present petitioner may be stayed in disposal of the present petition. थोड़ा गर्म लगा है एक चला गया वो तो एकदम डायरेक्ट होगा चल रहा है ना उसका वो भी चल रहा है that one was also this one and this one that one next one Mr. Pada the learned standing counsel ACB raised payment objection and submitted that it is not at all a case for passing any order on stay, and it's a serious offense wherein the allegation of more than 70 crores, misappropriation of more than 70 crores has been alleged. He submitted that 2 FIRs were filed in connection with this case. In the earlier FIR, there was an allegation of misappropriation of more than 70 crores, and subsequently the subsequent FIR. But why he has this one only 71 crores if the earlier FIR,
Yes, ma'am.
as you have said that in the earlier FIR, what was the amount? Can you tell us?
Earlier
In the first FIR, my lord, that was against the petitioner was that firstly that I was appointed politically, my lord, and then secondly 71
No, but
crores.
Earlier, in earlier FIR, what was the amount?
71 crores.
71 crore 29 lakhs.
So this charge is of 71 crores.
However, my lord, thereafter again, another FIR was filed, my lord.
Against the accused number one.
This is in connection with number one.
Yeah, no, both.
Both.
This is for accused number 1, my lord. And again, for accused number, the other accused person and the petitioner, my lord, there was an allegation of embezzlement of 5 crores. Now, since the investigation was already going on, and since
Both the FIRs were amalgamated.
yeah, since this 5 crore was under that 71 crores, this case was amalgamated with the 71 crores case.
No, that's why I'm asking it. In the earlier FIR, the first FIR,
Yes.
there was an allegation of embezzlement of say 71
My lord.
crores,
My-
like 29.9 lakhs, so and so.
My lord.
And subsequently, with the another FIR was lost, wherein the matter of 5 crores were involved.
Yes, ma'am.
Both the FIRs were amalgamated.
Yes, ma'am.
But while framing the charge,
Yes.
if you go to the second
Eh,
charge,
My lord.
it is only 71 crores. If suppose 5 crores is also added, or it is in one.
No.
with
All together.
all together.
All together.
In the charge sheet, there is only a mention of 5 crores, not 71 crores.
We hope for submitted that the 2 FIRs were lost in connection with this case. In the earlier case, in the earlier FIR, there was an allegation of embezzlement of 71 lakhs, 71 crores, 29 lakhs, 1,045. And in the subsequent FIR, there was an allegation of embezzlement of 5 crores, which is included in the 71 crores. Accordingly, he submitted that both the FIRs were amalgamated, and the investigation was completed, and the charge sheet was filed accordingly. He further.
Sorry to interrupt, your lordship. Just I want to make one clarification, madam. That second FIR was against the accused number 1. That is just, it was against the accused number 1 that he has misused the amount of 5 crores that was given on loan by the bank.
The other.
Yes, Federation, madam. It was against the-
Second FIR, that data consent reflection, and the second FIR was lost against the accused number 1, T. Bhagat with the allegation of embezzlement of 5 crores. Full stop. Next para. Mr. Pada, the learned standing counsel, so and so, further submitted that this is a very serious nature of case wherein the charge has already been framed and the regarding the prosecution sanction and other misappropriation, etc., will come at the time of trial. But considering the allegation brought against the present petitioner, it is not at all a fit case wherein this stay can be granted in respect of the stay can be granted for the present petition. However, he insisted that matter may be disposed of in an earlier date, and accordingly he insisted to call for the scan copy this year. Next para. Considering the entire facts and circumstances of this case, the entire and on perusal of the entire charge sheet and the other matters on the record, in the earlier case, your 71 crores, you were there then.
Yes, that
In
was
what?
against me, yes. But no amount as such, nothing is there, my lord, charge sheet. The charge sheet, entire charge sheet talks about 5 crores only.
Then you will see the charge sheet is for only 5 crores.
Only 5 crores.
70, there is no mention of about
There-
71 crores.
Nothing, nothing
There
there,
is no be mentioned.
Investigation, I don't know.
only the
That
charge.
part, your submission that the member was not present, are the, what is this? the
RCS.
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 That approval was not there.
Approval, but the deputy secretary was himself present in that meeting where the minors were taken out.
Deputy was there. Deputy was there.
Deputy was
But
there.
he was representing the concerned office or the concerned authority. That may be
Yes.
one of the aspects.
My lord.
Nabard was
Concerning
also
the,
there, ma'am.
Hereby, I find it proper to pass a the other one, only state is the party, I think.
Only
Only
district.
No formal notice ki agot likhi diba. Copy, you need a copy, na?
I've already.
I've already
already.
got.
Only till next date of listing. It will be listed after 3 weeks, we'll do,
My lord.
list after 3 weeks.
Deeply.
इससे उनका सबमिशन है उससे पहले ही call for the spell copy of any and issue notice, no formal notice is required to be served, this one can be done. लिख दे नहीं नहीं हाँ ये stay further stay till next date of listing.
This petition,
Item number 7 full answer. State is not the party yet.
State-
Item number 7.
it is against the domestic violence. So
अच्छा
I have challenged the proceeding of domestic violence filed by the wife of petitioner number 1. She has filed the
item number 9. So pause once again. Is there anyone? Item number 9. No one is there. Because they have already entered into appearance. I
Yes,
think
yes,
they are
yes,
there.
yes, they have already entered.
So basically you are on for the stay or
Yes.
after hearing
Yes, yes, yes. For the stay only.
for
Today,
stay.
today I am for stay only.
Then in absence to it's not be should not be passed. AK Mishra is here. Name of AK Mishra is reflected in the cause list. Mr. Mishra is from actually he comes from Guwahati. It's not
From
available.
Tinsukia. Yeah.
From Tinsukia.
Yes, my lord.
Okay. Heard Mr. Udeka, the learned counsel for the petition of solely appellant. The respondent side remain absent, though the names of 1, 2, 3, 4, 5, 5 numbers of advocates are being shown in the cause list. However, for the ends of justice, let the matter be listed. When will be your convenient date?
After 2 weeks, my lord.
But there is no, I'm asking, after 1 week.
1
better,
week, yes,
na?
yes,
Because
yes,
stay
yes.
is not there.
My lord. After
Yes,
1.
the matter according after 1 week. Raised you will do. Okay, we are listing it after.
Okay. Highly obliged.
You have received the record, na? Trial court record. So you are for the petition?
Yes, I'm for the petition. What's this criminal petition is filed to pass this FIR, FIR dated 24/9/2029, and this matter has been charged against the accused person. And this it is the matter of your law. This case is being tried before this honorable CGM, and it has been same charge against the accused person only under section 498, and the section is non-compundable, and so the board party has settled the matter. Lordship, this is
So
page number.
number 1 is the victim informant and the number 2 is the accused.
Yes, and page number 59. Lordship, kindly turn page 59. This is 50. Oh, sorry, 57. This is the settlement, deed of mutual settlement by the both parties. And the application is filed to the court and set aside this criminal proceeding against the accused person.
What is the stage of the case at present?
It is
What is the stage?
it is evidence.
At the evidence stage. Why you waited so long? If your husband and wife, you're staying together, at present you are staying together or what?
Yes, now they have mutually settled and now staying together.
But this mutual agreement is only on 18th of September 2024.
24 years.
When FIR was launched,
FIR laws on 24/9/2029.
24/9,
19 year, 19 year.
19,
Yes.
19.
2020.
2020.
Lordship, in this case, different FIR were lodged by this petition number 2, wife. At Sagali also, and this Itanagar Fias also. Now this FIR has been made in club, and this FIR has been charged sheeted. And FIR.
Both the FIRs are clubbed together.
Yes. Now this only FIR number 122 12/2022 is being tried before this CGM. And this case is and evidence prosecution witness has been on this case. Already some other maintenance also has been taken from this honorable court.
Maintenance cases are still going on, it's maybe withdrawn.
Yeah, it has been withdrawn, Lordship.
Yes, MS. Heard Mr. Your Mr.
T. Tamin, Lordship.
T. Tamil. Heard Mr. T. Tamil, the learned counsel. But also heard MS T. Jini, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Tamil that both the accused petitioner as well as the informant victim had jointly filed the present petition. Petition as petitioner number 2 and 1 respectively. The further submitted that both the petitioner and both the petitioners are staying together as a husband and wife without any differences. He further submitted that as the case has been registered and transited under section 498A. In this case, charge has already been framed,
Yes,
transited and against registered and transited against the present accused petitioner under section 498A, which is a non-compoundable offense. The matter could not be compromised before the learned trial court beginning. There is no possibility of giving any so and so, and state has no objection if the matter has already been compromised. So we are going to compromise your list.
duly obliged.
Disposed.
Item number 13.
Will I appear on behalf of the respondent in this case, Lord?
Respondent.
Yes, Lord.
Why
Lordship,
the
this
I is for? I is for?
Lordship, I
I is
stay.
for? Huh?
Stay.
I is for stay.
Yes. Lordship, this is an appeal against the order, FAO,
What's
passed by
FAO?
the Learned District Judge, UPR, wherein the interim injunction granted to the appellant has been vacated by order.
So you got the interim injunction order in your favor?
Yes, Lordship. So, Lordship, fact of the case is that I had entered into an agreement with the respondent for construction of an commercial complex known as Sumpa Complex, Itanagar. So, pursuant to the agreement, I've mobilized significant expenses. And suddenly, in the month of November 2023,
For construction of what thing? For construction of?
for building, commercial building.
Commercial.
Yes. And Lordship, in the month of November, I was forcefully ousted from the construction site without any reason. So, Lordship, I was compelled to file the commercial suit for declaration that the agreement entered between the respondent and the appellant be valid and binding on the
This is the position. How
respondent.
can you hear anything from him between this? What kind of problem was it?
My friend is audible, Lord.
You are audible, but you are not, your video is not working. This is the position, how can you?
May I, Lordship?
How can you? This not working. Now see the other side. Condition is unstable. Deepa,
I think this. Damages of Lordship 1 crore 41.
no, earlier injunction was granted in your favor.
Yes,
Acha, then
Lordship and would also claim for damages of rupees 1 crore 30 lakhs 41,524.
in the injunction petition itself or subsequently you filed?
No, Lordship, in the commercial suit itself in the prayer portion
Okay,
was
no, that is still there. You
Yes.
have paid for a competition, yes. No, what was the ground for your vacation of your injunction order?
Lordship, it was vacated on the ground that the amount that we have mentioned here, that is 1 crore 30, is ascertainable,
Is
can be ascertained.
cannot be asserted.
Can be ascertained, that's why specific performance cannot be granted. On this very ground, it has been rejected that no prima facie case is made out, since the amount of damage that we have claimed is ascertainable. Your Honor, the amount that we have mentioned is a rough estimate of the loss that we have suffered. And it's not an accurate estimate that much damage has been caused to us. Because we have not shown any method how the calculation was made. We have just mentioned the amount as a rough estimate. Since we are to receive a 60 lakh amount from the respondent also and 70 lakhs as damages. In total, we have claimed 130. And Lordship here, learned judge also has stated that the balance of convenience is with the respondent without stating as to how the balance of convenience lies in favor of the respondent. The only observation is that in event of stay, it will be convenience for the respondent. So there is no reason why balance of convenience is in favor of the respondent. And Lordship, even the judges failed to state as to why irreparable loss will be caused to the respondent. Here also, the only observation is that if the defendant is restrained from construction, irreparable loss will be caused. It's not stated as to how loss will be caused to the respondent. And Lordship, here, no hardship has been caused to the respondent because of the stay which was granted to us, because Lordship, the copy of injunction was served to them on 20 April 2023. Oh. I'm sorry, Lordship. This is the injunction order. This was served to them on 25th.
Your order. Have you annexed?
Yes, Lordship.
So 12,
Lordship, we have not
12,
annexed it.
11, 2024 is the order whereby your injunction was vacated.
Yes,
That is the
we have annexed
order
it. Yes.
challenge.
Lordship, here the injunction order was served on the respondent on 25th May 24. After that, the respondent did not file any application for vacation of stay only in the month of August. Lordship, that is after 3 months. They filed an application under Order 39, Rule 4 for vacation of the ex
When?
interim order.
When they filed? On?
August, Lordship.
August.
Yes. This is after 3 months. Lordship, where no prejudice has been caused to the respondent because of this stay. Because they've filed this vacation for stay after 3 months. So this is my case, Lordship. And the order dated 11/12/24 has been passed without application of mine. So Lordship, so the impugned order may be stayed. And records may be called for it.
Wait, please, Your Lordships. Am I
Yes.
audible to Your Lordships?
Yes, yes.
Blood, it's like this, blood. I have a building, blood, and I have engaged a person from Delhi. Now, rates have been finalized, contracts have been entered into it. They have brought some materials and they started construction, but they could not complete it. Your Lordship will kindly take note of the fact that the due date of completion was December 2023. I'll just straight away take your Lordships to the agreement. That would be relevant. If your Lordships kindly come to page 55 of the memo of appeal.
Yes.
Blood, your Lordship would see at the bottom, the time period has been written. January 22 to December 23. Has your Lordship got it?
Yes.
Now, my lord, it is their own pleaded case that they could only complete up to November 60% of the work, 2023. And though there is no substantial substantial statement to the effect, what is the value of the equipments, in their annexure, they have annexed which comes to around 15 lakhs, Your Lordship. Now they have filed this suit in 2024. By that time, December 23 has already gone by. So an agreement which has already been expired, how could it be binding and specifically enforced? Now, if your lordship sees the prayer in the suit, that is at page 40.
Yes.
Pass a decree declaring that the agreement dated 21/12/21 is valid. It should be invalid. They have written it void anyway. Operative and binding. When the period expires, lordships, there is no question of any extension and binding effect to that. Only the issues that can arise out of that agreement can be adjudicated, which is being adjudicated. Now your lordship would see, pass a decree and order directing specific performance of this agreement. When the time itself has elapsed, how could a specific performance of that agreement could be performed? Now, the next order your lordship would see, next prayer, pass a decree on order permanent, prohibitory and mandatory injunction directing defendant to restore the possession. This is a disputed fact, your lordships, that can only be adjudicated during trial. And pass a decree and order of permanent, prohibitory and mandatory, the prayer D I am reading, restraining the defendant and employees agents from carrying out the works of the project site by a third party agency using machinery and equipment. As regard the use of machinery and equipment is concerned, that is disputed. The restraint is as regard third party cannot. Lords, my building is being under construction. I am losing rent. I have borrowed huge amount of money from bank. And if they stop construction, who is to lose? It's me. And so far as prayer E is concerned, your lordship would see, pass a decree and order of damages, 1 crore 30 lakhs. So when you have a claim for damages and that need to be adjudicated, how irreparable loss can be incurred to the plaintiff petitioner lordships? It is me who is losing because my work was stayed. It's a different matter after the order of injunction that has been rejected, Lord, that we have completed our part of the work. So nothing left for the plaintiff petitioner to execute any work in terms of the agreement. So there is no question of any order of stay. Now, your lordship, if your lordship see the earlier order that ex parte order was passed against me, that in that order, Lord, there was no reason. It was a blanket stay of construction. And what the prayer in the main suit is that I cannot construct through third party. There is no bar in the prayer that I can carry out construction of my own, even going by the prayer. But the trial court, learned trial court, with due respect, has granted an order which was not even part of the pleadings. And we filed Order 39 Rule 4 application because certain facts were suppressed. And subsequently, when the matter was heard, we considered it to be an objection so far as Order 39 Rule 1 and 2 application is concerned. After hearing the lordships, the trial court has passed this order, vacating the interim order and rejecting their application. Now, your lordships, they have filed a stay application under Order 41 Rule 5. Basically, this is a stay of the order that has been passed. So once that order has been given effect to, it's been vacated, it does not automatically revive that order. Your lordships knows for any injunction, a fresh injunction application under Order 39 Rule 1 and 2 has to be filed. Because what the stay application, it only means that it would stay the order, but that's not going to set aside it until and unless the appeal is allowed. So my humble prayer before your lordship is, my lord, that your lordship can admit the appeal, but it will not serve any purpose. And so far as stay is concerned, there can't be any stay about the order. Your lordship has to decide it finally. And there is no fresh application under Order 39 Rule 1 and 2 seeking any fresh injunction. So that since their application is there, not there, there does not arise any question, Lord. Even on merits, they don't have any case, as I have shown to your lordships. When they are seeking damages, it's very clear it's specific relief. When you are seeking damages, you can't ask for specific performance of a contract. Otherwise, also, the period has already expired. Had it been a case that they had filed within the period of expiry of that agreement, perhaps that could have been possible. And that too for the period on which it expires, not beyond that. So therefore, I pray your lordship that the application should be dismissed. I am deeply obliged.
Okay, I'll pass you on.
I am so deeply.
Pass you order in. अभी मैं देखा ना एक बार कर लेते हैं हम इसको देखते हैं ना इनका जो इसके लिए मेरा Okay, I'll pass the order in Jim.
Obviously.
ये कितना वाला नंबर है ये नहीं अभी लाना नहीं 14 नहीं 14
Your lordship has item number 13.
Yes,
Mine was 13.
Yes. Yes. Now we have received. So this is where you have filed your I.
Yes,
for
ma'am.
impeding.
Implementing the complainant as respondent number 2, mother. That may be allowed, madam. That's a.
Oh.
Yes. Madam, on the merit of the case, my lordship takes up the
The merit, I'm not going to hear the on the merit today.
You're seeking entry, madam. Just, I'll take only hardly 5 minutes, madam.
You just complete your pleading first. How can we pass any order?
Madam.
Your pleading is not yet completed. It's not incorporated as a witness. We notice has to go.
Yeah.
Because in a case where the
Madam.
As serial number 20, Manoj Kumar Bora, the petitioner, he is an accused here. Now I will take your lordship to page 52.
You are Manoj Kumar Bora.
Yes, I am Manoj Kumar Bora, lordship. I am the accused, charge sheeted accused.
Yes.
So lordship will find at page 52 D3, the seized along with the relevant document, page 9, serial number 2, original agreement of sale between Manoj Kumar Bora and Karkan Gamdir has already been seized. This is the subject matter of this particular affair also, the Doimuk affair. The affair laws before Doimuk. This particular document has been alleged that this document has been forged. This forged document has already been seized. So there is no opportunity to tamper. This was sent to forensic. Forensic has given already a report. And at this stage, I don't want to reveal my defense because charge sheet has been filed. I have to appear. Someone has been issued. I have to appear. Now, on the same facts and circumstances, the informant has filed the present affair. Now, my only respectful submission is that whether the particular document which has already been in the custody of the court, whether my custodial interrogation is necessary for that allegation, same and one allegation. That is my, because already he has filed a application for cancellation of bail in respect of Lotashil that was rejected. An order I have already placed before the court master. My only respectful submission is that I am not on merit that whether the document is forged or genuine. because already charge sheet has been filed. So prima facie, police has come to a finding that that particular document is false. Let us assume at this stage. Now, my only respectful submission is that whether my custodial interrogation is necessary for the said particular document, which is already investigation into and charge sheet has been filed. Because already he has come for cancellation of bail granted by additional district judge Kamrup at Guwahati. That application was also rejected. Now, on the same circumstances, I was earlier granted by the Honorable Guwahati High Court bail.
23.
Annexure 3, page 23. I was granted bail. Lordship will find Manoj Kumar Bora, 438 applications on the same facts and circumstances that I obtained bail application. I submitted a forced sale deed agreement to obtain bail. This is
Where is the FIR of the present case?
Page 14, Lordship will find. Page 14, Annexure 1. May I read, Lordship?
Yes.
Sir, I would like to, I would leave to bring into your kind notice that Manoj Kumar Bora, so-and-so, file an anticipatory bail application being AB number 12 of 23 before Honorable Itanagar bench of this Honorable Guwahati High Court, UP, Assam, containing fraudulent documents. It is pertinent to state here that use of fraudulent documents with intention to cheat amounts to criminal cognizable offense. Praying for registration of a fit and proper FIR against Manoj Kumar Bora under appropriate section of law for the end of justice. A copy of the anticipatory bail application, bail petition AB number as stated above is attached herewith for your kind attention. The said anticipatory bail petition contains agreement for sale and as Annexure 5 on page 23-25, which is fraudulent in nature and subject matter of the complaint. That agreement I have annexed as Annexure 4 at page 25 along with this petition. The said fraudulent document were used by the accused Manoj Kumar Bora in utter criminal conspiracy amounting to criminal breach of trust amounting to criminal cognizable offense. I'd like to state that the accused Manoj Kumar Bora has used the said fraudulent document earlier in his anticipatory bail application AB 323919 filed before the Honorable High Court at Guwahati with relation to Dibrugarh PS FIR number 442/18 and FIR for use of fraudulent documents was registered at Lotasil PS under which jurisdiction Honorable Guwahati High Court falls, being FIR number 78. So all these documents were annexed. Now I will take your honor to Lordship to page 25, that particular document alleged to have been forged. This document was executed between one Karkem Gomdir and Manoj Kumar Bora. These particular documents alleged to have been forged. This is the subject matter of Lotasil PS and the present affair. And Lotasil, the police has investigated and they have seized the document. It is in custody of the court now. And the documents was sent to FSL, report has been received. There is nothing left for investigation. The custodial interest, with all respect, Lordship, in the nature of allegation, custodial interest with all respect, Lordship, is not necessary. Because already by Lotasil PS, all the investigation it has completed. They have sent the document to FSL, they have seized the document, they have filed a charge sheet. Everything, investigation is complete. So far, the allegation is concerned. Because the subject matter in both the cases are same. The issue is that whether this document is false or genuine. Now that defense I cannot reveal at this stage because it may hamper at the trial. So I may restraining myself to disclose the defense. Just I would like to submit, Lordship, whether his custodial interrogation is
Okay, you
necessary.
join us at 2. We'll resume this. You through virtual mode, you join us at 2 p.m.
Lordship, Lordship.
You go by the case diary.
Yes, Lordship.
Testing.
Lordship, in the case study, Lordship, the investigation is in the initial stage. Lordship, during the Lordship, investigation is revealed that Lordship, that is Lordship, when they have filed Lordship AB in the Lordship, yeah, 2023 before this honorable court, they have fortunately they have produced the document with his Lordship, forged documents, Lordship.
In earlier AB.
Yes,
number,
Lordship.
AB number.
Yes, Lordship. This is here in
Chapter
this
6.
petition. In their petition, Lordship, in the page.
Annexure 6, Lordship.
Page 33.
Page 33.
Page 34, Lordship.
30.
33, 34, yes, Lordship. Lordship, on the basis of that, Lordship, this new course of action has arisen and they have lost the FIR in the Doimo PS. And Lordship, during the investigation, it is revealed that Lordship that accused is a habitual cheater and making forgery not in this court, Lordship. That this earlier this other PS, Lordship, sorry, in the case, Lordship, which is Lordship pending, Lordship, before the Dibrugarh court, Lordship. That is FIR Dibrugarh PS 192/18, which is still pending, and Lordship, but their AB was dismissed, Lordship.
In
And-
connection with Dibrugarh.
Yes, Lordship. Dibrugarh PS 442/2018, which they have not annexed in this petition. And their AB number 2017/19, which is dismissed with a direction
AB
to
number.
AB number, Lordship, 2070/2019, which was dismissed, yes, with the direction to taken the accused into custody. And Lordship, again, they have filed another Lordship AB with the forged document, which is allowed, Lordship. And then again, Lordship, that is, just inting was allowed, but this is pending before the Honorable Justice P.J. Sekia and the principal bench.
No. Which was allowed?
Lordship,
AB
and the-
number.
AB number
Annexure 3, page 23, Lordship. The state order.
3239, 2019, Lordship.
Annexure 3, Lordship.
Annexure T, page 23.
23.
They are also, they have.
This AB 332939, they have obtained the anticipatory one.
Yes, Lordship.
In connection with which case, this one?
Dibrugarh PS,
Dibrugarh.
Lordship.
Then subsequently you have submitted that was rejected.
Yes, Lordship. They have us rejected, but they have again, they have with the new ground, they have again, they have filed, Lordship, another AB.
Now, informant has come for cancellation of this bail petition, and that is pending. Tomorrow is the case fixed for that petition. Before the
Tomorrow,
Honorable
this
Guardian.
hearing of that petition, Lordship. Lordship, earlier allowed, but again it is under challenge, and this hearing is fixed for tomorrow, Lordship. Before the Honorable Justice P.J. Sekia.
That is the order against 14/11/2019 is being challenged.
Yes, Lordship.
In this case, Lordship, Honorable High Court called for the status report of the Dibrugarh PS. And tomorrow is the case fixed.
Lordship, so Lordship, my humble submission that Lordship, at this stage, this bail should not be granted because it is every likelihood of tampering evidence and to the prosecution witnesses. Because this is something, Lordship, this is not Lordship, the easy Lordship available. This is way for to the 17 FIR was lost Lordship. It is now still going on, and if investigation could not completed because that person whom once they have obtained this interim also they did not comply again lordship they have absconding and again they have lost lordship file fresh AB lordship and that conduct is itself lordship is reflected that that person is not lordship liable to be lordship grantee interim protection. He should be custody integration needed lordship such kind of lordship conduct lordship. Moreover, lordship here, other co-accused lordship, we can say here lordship, they have been notice been issued, but they have also been evading the arrest. They could not lordship appear before the IO for the investigation.
Other co-accused persons.
Yes, lordship. And the two again accused persons. That agreement lordship here lordship they have annexed lordship. He the other person. And the doctor lordship whom he have obtained that medical certificate, that is also seemed to be forged one.
When it was obtained?
Lordship, during that after they have obtained the AB lordship in the lordship Dibrugarh, sorry, this case lordship, Dibrugarh case lordship. So the main accused lordship this Manoj Kumar Bora. So he's not entitled to this bail interim protection at this stage. So if lordship is want to go to the is the case.
Yes, want to submit.
The statement of the complainant and all that is lordship investigation report is here.
Lordship, before I take you to the brief facts of this case, may I take my lords to page 3, para 3 of this petition? May I read, Lordship? That the accused oblique petitioner begs to state that the accused oblique petitioner is totally innocent, as in no way connected with the alleged offense, that the police personnel recently, in the absence of the accused oblique petitioner, visited his residence and finding the accused oblique petitioner absent, instructed his family members to send him to the Doimuk police station. That the accused oblique petitioner is now apprehending arrest in connection with the aforesaid case, as the case is registered for commission of a cognizable and non-bailable offense. Lordship, he says that the police came running after him, and from that he comes to know. I have on the request obtained a status report from Doimuk PS. May I be allowed to furnish that status report to your Lordship and read the relevant paragraph? Investigation so far, the second page. The FIR case was received on 26/12/24, but kept it under inquiry to find out whether such document was used by accused person as a genuine document at our jurisdiction, that is Guwahati High Court Principal Bench UPR. During the course of inquiry, CTC of the said documents was applied and received and found that such documents was used as genuine documents in Guwahati High Court Principal Bench UPR and recommended for registration of case under appropriate sections of law. During the course of investigation, the statement of complainant was recorded under 161 CRPC in separate sheet of paper, and statement of complainant is collaborated with FIR. Issued notice under 41A. Lordship, here comes the suppression of fact. I am not going into what has happened before. I am saying that look at his conduct, what he has done in this court now. We are not into what has happened from 17 to 25 before coming to this court. In paragraph 3, he says the police came hunting for him. And from that hunt, he comes to know that there is a case. The investigation says 41 for CRPC through WhatsApp and through WT message to OC Biswa Charlie and OC Pasigat respectively to alleged accused persons, namely Manoj Kumar Bora, son of late Kosheshwar Bora, and Sri Karken Gomdir, son of Sri Gekir Gomdir, to appear before the ION 13/125. Lordship, this is notice number 1. In compliance to notice, Sri Manoj Kumar Bora submitted a medical report issued by Dr. Dhrubojyoti Fukan, MS General Surgery of Biswanath Charlie, dated 13/125, that the alleged accused Manoj Bora is suffering from lumbocervical disc recession from 2012-24, but alleged Mr. Karken Gomdir, son of Gakir Gomdir, never complied nor communicated through any means. Lordship, notice number 1 gone. Hence, again served a notice under 41 CRPC to duo Mr. Manoj Bora and Mr. Karken Gomdir and transmitted WT message through OC Police Station Biswanath Charlie and Pasigat respectively to appear before the undersigned on 18th of January at 10 hours at PS Goimu. In this regards, a reply received from OC Pasigat that alleged accused person Mr. Karken Gomdir is out of station and whereabout not known, while no communication received from OC Biswanath Charlie. The medical certificate issued by the doctor seems to be fake, since our source informed that alleged accused Manoj Bora is fit and fine and roaming here and there. Hence, a 41A notice and a 91 CRPC notice was issued to Dr. Dhrubojyoti Fukan to appear and produce requisite required document on 18/125 at 10 hours and also contacted over phone, but he denied appearance on given date. Again, a 41A CRPC notice, 91 CRPC notice issued to Dr. Dhrubojyoti Fukan for appearance and production of required document. Further, on 23/125, I prayed for non-vulnerable warrant of arrest against the duo arrested accused person, namely Mr. Manoj Bora and Karken Gomdir, and it was listed on 3rd of February. But unfortunately, I was on leave on urgent domestic ground work and matter was not considered. After joining from leave, I again prayed for NBW against the DO accused persons, namely Manoj Bora and Karken Gomdir, and the matter is pending before Honorable CGM UPR. Further, it is to inform you that as soon as the NBW obtained from Honorable CGM Court, the raid will be conducted and arrest of the accused persons. Lordship, it is a settled fact, which is called suppressio veri suggestio falsi. When you suppress the truth, you promote the false. What he has done in the last 8 years is going to be considered later. Here he again cheats the court. He was issued 241 notices and he is pleading that he is coming to know of the cause of action from a hunt by the police. This petition is hitting at the very root of the law system. This petition is not maintainable. If we go down the observations of the apex court from Singal Gaya Naidu, Jagannath 1994 up to Bilkis Bano, it is a settled law. Suppression of fact makes the petition non-est. It's a nullity. May I place the relevant judgment before your lordship? We will not go into the merits of the case. This petition cannot be entertained because on the face value of the court, he has played a fraud again by suppressing facts. And suo motu action needs to be taken against the petitioner. Now, lordship, coming to the brief fact of this case. This case has been lingering on from 2017. What has happened? My mother is the owner of some excavator. She entered into an agreement with a person in Dibrugarh and lent out her 4 excavators on hire to him. The person took it for 4 months, but neither paid the rent nor returned the excavators. He sold them off. For the convenience of this case, may I put my mother, the owner, as A, the person who took it on rent as B. He is Mr. D. During the course of investigation, when the excavators were being found out, he came out with a petition in Dibrugarh court when he was served a 41A notice that I am a humble person, I have got nothing to do. A status report came up that you have, say, 1, 2, 3, 4, the 3rd excavator with you on a mortgage. His bail was rejected in Dibrugarh, Guwahati High Court related to Dibrugarh court, with a direction to be taken into custody. After 3 months, he comes with a petition saying my lawyer suppressed the facts. I have one, learning from the orders of the court. And that is not number 3, that is number 4D. So if you are saying I have number 3, how can you attach the documents of number 4? Another fraud plate. We filed an FIR with Lata Cell because the cognizable offense was committed. He has been charge sheeted. The magistrate has taken cognizance. Summons issued. He never appears. Bailable warrants, non-bailable warrants, everything issued. Now that particular bail is under challenge to be heard tomorrow in the court of Honorable Justice P.J. Saikia, item number 40. In that particular cognizance order, the magistrate has even brought the notice attention of the Honorable Registrar Vigilance and SP Dibrugarh because he was charged sheeted under 199 and 200 IPC, which can be taken care of only on the complaint of a public servant. Since I am in private, they brought the attention of the court through Registrar Vigilance that this is barred by limitation under 468 CRPC to do the needful. That is also pending through an interlocutory, that is item number 41. Now coming to this lordship, the first excavator was seized in Sejusa from this person. The excavator was seized. He came up with a document saying, I have got it on mortgage for 15 lakhs. But in Dibrugarh court, he suppressed it. He said, I am an honest businessman, I have got nothing to do. The Dibrugarh FIR mentioned every aspect of the excavators, all the 4 in details. This Sejusa FIR is transferred to Mariang PS. When Mariang calls him under 41A, he comes running to this court saying that I am an honest businessman, I have got nothing to do, I purchased something, this is the agreement. And he obtains a bail on that particular submission. Now, Lordship, when that particular petition comes to my notice, I find the same fraudulent document attached here which he has attached there in Guwahati, related to Dibrugarh case, for which he has been charge sheeted. Now, if it is a fraud there, it is a fraud here. Though it is not a mini trial, we are bound within the 4 corners of this petition. So if he has attached a document which is fraudulent, that has to be taken care of. Now the police has issued a notice under 41A to the best of their humbleness, obeying the laws. Where a 41A notice creates an apprehension of arrest, it is not an advance notice of arrest. If you are so innocent, go and join the investigation. You can come to Itanagar before the Earth Commissioner, but you cannot go to the police station. What is your conduct? Now you have filed a petition stating the police came running for me. You hid the 41A notices issued twice. Now you got a false document from the doctor stating you are on bed. The doctor was called, he did not turn up. Lordship, how can such a fraud be allowed in this court? So it's like peeling the onions. You remove one layer, the another comes up. You remove the second layer, the third comes up. Every FIR lodged against him has culminated into a charge sheet. Cognizance taken. He has not appeared in anybody. He is under warrants everywhere. Is this the conduct of a petitioner? How can he come to the court saying that the police came to me? Did not you receive a 41A notice? And if you received, why did you suppress? Suppressing fact amounts to playing fraud on the court. He is a habitual, recalcitrant, ludicrous offender, Lordship. The 4 excavators are yet to be recovered. All total 30 persons are involved. The SIT of Arunachal Pradesh has charge sheeted its own DSP and IO in that case. When he says he is a law-abiding citizen, he is making a mockery here. He is a law-avoiding citizen. I don't go into what has happened in the last year, 8 years. Lordship, I am purely on paragraph 3. That takes care of this petition. You don't say you are issued a 41A notice. The status report says you are issued, you replied that you are sick, the doctor was called, you did not come. That makes this petition non-maintainable for suppression of fact. I have handed over the latest judgment of Bilkis Bano, where it is categorically stated, suppressing fact amounts to playing fraud on the court. And that I will pray to this court to issue a further action against him under 340 CRPC, read with 195 IPC, which was the last sections. I don't know the present sections under BNS. They have made, Lordship, if we go by the judgment of Gurbakh Singh Sibia, it is clearly said anticipatory bail is an extraordinary discretionary jurisdiction. But they have made it a blanket bail condition. If you are issued a notice, you come to the court for bail. But you don't challenge the notice. You don't challenge the FIR. How can you challenge? You are guilty. You only want not to be arrested, not to be taken care of, so the trial continues for years together and you enjoy the freedom. Can it be allowed? In Sakiri also, it is said the High Court should least interfere into the affairs of the investigation and all. All this applies. This is a constitutional court. If you suppress information from this court, you have played fraud with this court. This petition is not maintainable, Lordship. Question of interim or absolute or nothing arises. First, he has to answer why he suppressed the 41 notices.
Oh.
Yes.
Heard Mr. J. Allen, the learned counsel for the petition, and also heard MS Al Hadi, the learned additional VP, appearing for the state respondent number 2, and also heard you, Mr.
Manish Kumar Agarwal.
Manish Kumar Agarwal, the informant, appeared in person. Next part, this is an application under section 482, BNSS, being for grant of pre-arrest bail to the accused petitioner in connection with Doimo Police Station case number 03/2025, registered under section 120B, 420, 465, 468, 471, 193, 34 IPC. It is submitted by Mr. Alam, the counsel for the petitioner, that the present petitioner is innocent, and he was in the he was in another earlier earlier FIR was also lost against him with the same set of allegation, and the present FIR is also lost. Earlier FIR was lost against him, wherein the case was charged and with the same set of allegation, the present FIR has been lost, wherein it is alleged that he produced some false document. FIR is, where is the FIR here? FIR is the annexed page. Mr. Alam, FIR is the annexed page.
14, Lordship.
14.
Page 14.
Production of some fraudulent document. Production of some fraudulent document. Basically, the agreement for sale, which was a fraudulent in nature. Full stop. The present FIR is filed before the Doimo Police Station with the same set of allegation regarding the production of some forged document, that is the agreement for agreement of sale, which has been annexed as annexure 4 in the present petition. Next paragraph. He further submitted that from the charge sheet itself, it is seen that by its user list, the original of the agreement for sale, which is the agreement for sale, has already been seized. Already been seized in connection with
Lotasil PS, Lordship.
Lotasil PS case number 78/2021, which has already been charged. Thus, Lotasil PS case number, it is evident that the document which is alleged to have been forged, or where it is alleged that about the production of the forged document, is already in the custody of court, as the case has already been charged in connection with Lotasil PS case number 78/2021. Accordingly, at present, the custodial interrogation of the present petitioner is not at all required, However, he is ready and willing to cooperate with the IO in the further investigation of this case. You said that one cancellation of bail prayer was rejected, na? In connection with which case, Alam?
Lordship, Latashi. Latashi, I have
There was
submitted
a
the
prayer
copy
for
of
cancellation
that
of bail.
one.
No,
Bail.
there was a prayer
That
for
was
cancellation
rejected.
of bail.
That was rejected.
What is the grounds taken by the district judge?
I was granted bail.
Bail was not granted on this fraudulent document. I have the order with me. I can-
Okay, no, it's okay. He further submitted that the bail, the cancellation, the prayer for cancellation
Lordship
of
will
bail,
find Annexure 8, Lordship, page 47.
cancellation of bail,
Annexure 8,
prayer
page
for
47.
cancellation of bail, filed by the prosecution was also rejected by the learned additional session judge number 1 in connection with AB number 215 of 2023, dated 30/06/2023. However, he is submitted that the petitioner is ready and willing to cooperate the IO if he is granted with the privilege of pre-arrest bail. Next para. MS Al Hage, the learned additional PP, submitted that the case is of serious in nature and the investigation, and from the status report submitted by the IO, it is seen that this case is still at the initial stage of investigation. She further submitted that one AB application number 12 of 2023, which was filed in connection with Dibrugarh PS case number 442/2018, 2018 was earlier rejected by this court. However, subsequently another bail application was filed in connection with said Dibrugarh PS case number 442/2018. However, subsequently another bail application number 3239 of 2019 was filed, wherein the petitioner obtained the order of bail by suppressing some material facts and now this has been
Bail is
challenged,
still in challenge, Lordship.
and said order of granting bail is also under challenge, which is before the Honorable Justice P.J. Sakya, which is fixed on 11/3/2025.
12, Lordship, 12/3. Tomorrow,
Oh,
Lordship.
sorry, 12/3/2025. He further submitted that the cases against the present petitioner is pending before different courts since 2017.
Yes, Lordship.
Since 2017, and same applying fraud in every matter. He obtained bail in 2 occasions, and also obtained bail of this occasion. Further, is submitted that in such a situation, the custodial interrogation of the present petitioner is very much essential, and in the same time, two accused persons are still absconding, and they could not be interrogated by police. Full stop. Accordingly, she submitted that this is not at all a fit case wherein the anticipatory bail can be granted to the present accused petitioner. Full stop. Mr. Just sorry, Mr.
Manish Kumar.
Mr. Agarwal, the informant which appeared in person has submitted the status report of the investigation. Status report of the investigation. He further submitted in para 3 of the present petition. It is stated by the informant that he is innocent and no way connected in the alleged offense. However, in recently, in his absence, the police visited to his residence and instructed the family members to send him to Doimuk police station, and for which he came to know about the same and now apprehending of being arrested in connection with this case. Accordingly, it is submitted by him that from the status report, it is seen that from the status report submitted by the investigating officer, it is seen that one notice under section 41A CRPC was issued to the present accused petitioner, asking him to appear before IO on 13/1/2025. And in compliance of the said notice, Mr. Bora, the accused petitioner submitted a medical report issued by Dr. Dhrubajyoti Fukan, MS, bracket of General Surgery of Biswanath Sharali, certifying that the accused petitioner is suffering from lumbosacral dislocation from you can get the date here from 2012 to 2024. Thereafter, another notice under section 41A CRPC was also issued to the accused present petitioner, asking him to appear before the IO on 18/1/2025. And the medical officer who issued the certificate was also served with a notice to appear and to produce the requisite of the required document on 18/1/2025. But he denied to appear before the IO. And till date, the accused petitioner did not appear before the IO to cooperate in the investigation, complying the notice issued under section 41A CRPC. Thus, it is seen that further, it is submitted by Mr. That the accused petitioner had suppressed the entire facts of the case, and he produced some false and fraudulent document as well as submission, stating that he is innocent and has no connection with the present FIR. Though during investigation, it has come to the light of it has come to the knowledge of the court that 4 excavator which are yet to be recovered, and he already admitted about the position of how many? Two excavator, deal with them. Next for it, Mr. And so the informant in person further submitted that suppression of the facts itself amount to be fraud played with the court, and in that regard he also relied on a decision of Honorable Supreme Court reported in 1994 1 SCC page 1, and also relied on
Lordship WPC 91 of 2022.
Also they are done WP bracket of criminal of 491 of 2022. Accordingly, he submitted that the custodial interrogation is very much essential for the present accused petitioner, and it is not at all a fit case to grant with the protection of, grant with the privilege of pre-arrest bail to the present accused petition. Next paragraph. Considering the entire submission made by learned counsel for both sides, I have also perused the case record, the annexures filed along with the petition. This is the materials available in the case diary. From the entire submission and from the records, it is seen that there are three numbers of case. One connection to Lotus Hill, one Dibrugarh, and one Doimo.
Yes, Lordship.
3 numbers of cases has been pending against the present petitioner. Dibrugarh is charge seated? No.
No, Lord.
Not Lordship.
Continue.
It's still con-
And pending. And the Lotus Hill PS case number has already been charge seated. However, other 2 cases are still pending in connection with Dibrugarh PS vis-a-vis the present case, that is the case under the Doimo PS case number. From the various documents collected and from the materials available in the case diary also, it is seen that the present accused petitioner is alleged to have produced some fake and fabricated documents before the court, even while obtaining the bail order, suppressing the material facts. And one of the bail order is also under challenge, which is still pending before this court. Next paragraph. Considering the entire facts and circumstances of this case, nature of offense alleged against the present petitioner, and the other aspects of the case, I find that the custodial interrogation may be required to unearth some other facts of this case, and also for the interest of the just and proper investigation. In view of this, I do not find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner, and same stands rejected. Your petition stands rejected.
Lordship.
Lordship, Lordship.
Lordship.
Case diary may be written by Lordship.
Yes, CD may be.
Right.
Yeah, this was. Fifteen is disposed of, or what? 16, no? No? Yes, 16.
Your Lordship, applicant.
Here, it is here.
Your Lordship, on the last occasion, this court has directed for the scan copy of the TCR, Your Lordship. I have gone through the records. The records contain only the bail application that they have filed. The entire charge sheet has not been tagged along with the TCR, Your Lordship. If a reminder is sent to send the entire scan copy of the TCR, Your Lordship, along with the charge sheet.
No, on the last occasion also same thing had happened, no?
On the last occasion,
Your Lordship, this is third occasion.
Obviously.
Yes.
Otherwise, it is a charge sheeted case, no?
Yes.
Charge-sheeted case.
Yes.
Under which section it is called charge sheeted?
Under
103.
103.135 of BNS read with section 21A and 27 of NDPS Act, Your Lordship.
103 means what? Murder?
Murder, yeah.
Punishment for murder.
Murder.
Then 21 NDPS is also there.
Yes, 21 and 27, Your Lordship. Your Lordship, since we'll be requiring the charge sheet, Your Lordship.
What is the stage of the case as per you?
Your Lordship, at this stage, since the charge sheet has been filed by the IO of the case, so now the trial is yet to be commenced, and only for waiting for the trial, your lordship now.
This is the first occasion where the, I mean, it's not complete TSCR
CDS
has not
bail.
been sent.
Because during the pendency of this bail application, the charge sheet was filed, and therefore the TCR is called on the later
During
stage.
the pendency of this application.
Yes, yes.
Okay. We need the TCR because it's not only a case of murder, that too, the NDPS is also against the present accused petition. So the result of the case record will be necessary, especially the charges and all.
Your lordship,
Obviously, your submission is also correct, but the question is that during the pendency of this appeal only, most probably charge sheet was filed.
yes, charge sheet
So
was filed.
accordingly, TCR was called for.
Yes. Your lordship, charge sheet was filed on the month in the month of October, and the cognizance was taken by the district and session judge on 18th 11 2024, and since then the trial is pending, your lordship. So your lordship,
Will be there.
your lordship, otherwise, since in this case there were 5 accused persons, so out of 5 accused persons, all has been released on bail, except this present accused person. Yes, your lordship. Your lordship, I want to submit one.
No,
bail.
submission will here return. The question is that its TCR is not complete. So, at best, it has to come from which place?
From the court of sessions judge, your lordship, UPI. It's near.
UPS.
Yes.
You, Mr. N. Taji?
L Tatam, your
L.
lordship.
Tatum. Mr. L. Tatum, the learned counsel for the petition, and also had MSD, the learned additional PP, appearing on behalf of state respondent. It is submitted by MS Genie that though the TCR has been received, but it is not a complete one, except the order of bail. Charge sheet is also not there. No?
It's not there, your lordship.
It's an order of bail. There is even the charge sheet is not available in the case record. Accordingly, she submitted that the complete TCR has to be called. In full stop. In that context, Mr. Tatum submitted that this is the third occasion wherein the TCR is been awaited and awaited. Next one. Considering this submission, we'll file and counsel for both sides. Later, complete case record. Later, the scanned copy of the TCR be called for, and the concerned court is hereby directed to furnish the entire the complete set of TCR and full stop. Registry will do the needful in issuing reminder in that regard. List accordingly. Yes, you want any date or what?
$27.
Don't go by her submission, you take us.
Your lordship, on 26th.
26? 26 is a, oh yes, it's open. You can fix it a bit early also.
Earlier, yes.
26 also.
26, just in case, your lordship, because since they have stated, your lordship, they are, if they could have annexed the charge sheet also, it would have been convenient for us, your lordship.
26 will do. It's okay.
Your lordship,
26 is okay with you?
Yes, your lordship.
Okay.
Yes. Otherwise, your lordship, I want that 19.
19
I
may not reach also, I don't know.
Okay.
19th is a Wednesday, no?
Yes.
Yes, Gini, let it be on not on 26th.
On 20th in that case, your lordship.
20. 20.
Oh.
Deeply obliged.
Much obliged.
They have taken steps?
No, the step is
Not yet taken.
not yet. Your Honor, further for the step, further days may be granted.
Yes, Your Lordship. If on the last occasion, a direction was made to take fresh step, Your Lordship.
We have not taken steps.
Yes.
Yes, Your Honor.
Within a week, they may take a fresh step. Your Lordship.
So especially respondent number 1 is there only.
Yes.
One respondent.
Only one respondent.
Two.
2 is the state.
No, one is the state.
1 is state.
Yes. One is the state, only one private respondent.
2 is the private respondent.
Yes.
Not yet written. Only 1 EY, it's written as 1 everywhere. Oh, it's wrongly written. Anyway, state is 1, private respondent is 2.
Yes, sir.
You are Mr.
C. Peter.
C.
Peter. On behalf of MKC.
Appearing on behalf of Mr. MKC and also heard Ms. MST Jimmy from the office note dated 10/3/2025. This in that the fresh steps has not yet taken against the respondent number 2. Accordingly, the petitioner is hereby directed to take fresh steps within
2 weeks, Your Honor.
within 2 weeks. Steps for steps. Why? Within steps, we can await for service till 2 weeks. That is different thing. Within a weekly, we take step within a week and list the matter accordingly after 3 weeks. Take step.
Deeply.
Awesome.
It's a supplementary hearing. We can fix it for hearing.
The service is completed. Paperwork has been
Service
filed.
is completed means who is the is respondent number 2 is also there.
Yes, Your Honor.
Service is already
yes,
completed.
all the services. Paper book is also ready and TCR is also there.
No, but
We
it's
can
a
go for
case of
final hearing.
it's a case of POXO, I think.
Box.
Your Lordship.
Do one thing then we can do service report is noted received services awaiting
Through PS service was taken.
service report in respect to has been received from OC so and so. You can appoint an
Amicus, yeah.
Otherwise, paper book is also ready.
Yes.
My lord.
Yes.
One incident there was there. I was there.
For
Suspending the sentence and allowing the accused to go on bail.
no, it will the paper book is already ready. It's ready for
Then we can, my lord.
ready for hearing.
We can conclude it. We can conclude it, my lord.
Huh?
We can complete the hearing.
Yes, that's what I'm saying. We can complete the hearing, but before that, we have to engage one amicus to represent the respondent number 2. That's all.
Okay.
Heard Mr. You're Mr. Gupta. You're Mr. Gupta. Heard Mr. D.K. Gupta, the learned counsel for the appellate, and also heard M.S.T. Gini, the learned additional PP, appearing on behalf of state respondent. From the office note, it is seen that the service is already completed on respondent number 2. However, no one has represented the respondent number 2, and accordingly, considering the nature of case, I find it necessary to appoint an amicus to represent the respondent number 2. The registry is accordingly directed to appoint an amicus and to inform the matter accordingly. Paper book is already ready. Service is completed and thus the case is ready for hearing. Let the matter be listed, the act will be listed for in hearing column on the next date of listing. List accordingly when it can be listed after 2 weeks. If your matter is urgent, then after
4 weeks maybe.
After 4 weeks.
Okay, 4 weeks.
From where you have come?
From Tinsukia.
Tinsukia.
Yes. Because on the earlier matter, I have been given 4 weeks time. So I will take up both the matters together.
And in earlier matter also 2 weeks time.
4 weeks.
4 weeks. So you need that this is to be fixed after 4 weeks.
Yes.
Okay, just after 4 weeks.
DPF.
You take it considering the registry so that you can come once and
DPF.
otherwise paperwork is also ready. We are ready for hearing.
It will go for final hearing, ma'am.
Final hearing. The affidavit in opposition with Wakalat Kama has already been filed by you.
It is already filed, my lord, and in fact, otherwise, subject to your lordship's convenience, my lord, I could have paid for disposal.
No, I have some work actually.
My lord.
So otherwise ready for hearing.
Yes.
Where otherwise, is there any order of admission also there? It is already been admitted?
No, let it be listed for admission hearing then. Madam.
Pardon?
Let it be listed for admission hearing.
Admission hearing. And it can be disposed of at the
Because we have already exchanged the pleading. So for final hearing, it may be fixed within short days.
obviously, but order of admission is not there.
Madam.
Now, sometimes what has happened, in fact, what is happening? A hearing may not reach also. That's why I'm just saying that if it is in admission column, that can be heard and disposed of.
Yes, madam.
Because, yes.
The issue is very limited.
No, issue. I'm not on issue. The question is that hearing.
Madam, let it be listed for
I'm not
admission
in a
hearing.
position to
Madam,
hear
we
the
can
matter now. That's why
update it.
I'm not going to hear the matter. I'm just asking you that if it is can be fixed on the admission column, that disposal, the probability of disposal more instead of listing it on hearing column, because hearing it may not reach also. That's what I'm saying. Okay. Heard Mr. D. Soki, the learned counsel for the petitioner, and also heard you are Mr.
I can see. आज की होगा
কোনটো নাম আছে বিষ্ণু বর্মা
Monday. होगा सी.
M18 for the respondent from the office note dated 10/2/2025. It is seen that the respondent had already filed their affidavit in opposition along with the Wakalatam for the sole respondent. Let the matter be accordingly listed in admission column when after 2 weeks.
Madam, maybe on 24th, we are agreeing on 24th March, madam.
You want a fixed date?
Fixed date, madam. 24th of March. The issue, there was very limited issues.
24th of March.
All right.
Item number 23, legal aid counsel is there. Name is not here. Legal aid counsel, one legal aid counsel was.
Yes, my lord, but there is, your lordship, I just would like to point out, there is a gross irregularity in this criminal application. It's mentioned a jail. It cannot be a jail appeal, your lordship. Why? Because your lordship, earlier the conviction in the main case has been challenged before your lordship only. And that conviction has been upheld by your lordship. And later on they prefer SLP. And that has been rejected. The Honorable Supreme Court has not interfered. And subsequently, your lordship, they file an application under section 340 of the CRPC, alleging for complaint for perjury, your lordship, which has been rejected by the CGM. And they are now challenging that rejection order. This is not against the conviction or acquittal, your lordship. This cannot be a jail appeal only maintainable, your lordship. And your lordship will find, your lordship, here in my copy, they have only no annexure, nothing was there. Your lordship will find in the first post title only, your lordship. Your lordship will find an application under section 341.
Yes.
It cannot be a jail appeal, your lordship. An application under section 341, subsection 1 of the Code of Criminal Procedure against the judgment and order. It is not it's a final order, your lordship, passed by the learned special court Pokso Teju in Miss case number so and so 195, read with section 340 of the CRPC. It's not a appeal against conviction.
Then what actually is setting aside the above mentioned judgment and order. And then order passed by the special judge.
Special judge, he is
That is
eligible.
dated on 3/12/2024.
Yes, Your Lordship, that is after Your Lordship, the upheld by the Honorable Supreme Court in the main case, POXO case, main POXO case. This case is, Your Lordship, this is a miscellaneous criminal appeal. He has filed an application for preliminary inquiry under section 340, Your Lordship, for perjury, Your Lordship.
Yes.
Although evidence, everything has been appreciated by this Honorable Court, conviction was upheld by this Honorable Court. Later on, it was prepared before the Honorable Supreme Court. Supreme Court has not interfered. Your Lordship may kindly have a look on this judgment.
So now, as per you, what is to be done?
Your Lordship, this was, Your Lordship, this was the judgment just for, I would like to apprise this court. This was the judgment rendered by Your Lordship, and this was the, Your Lordship, SLP, rejection of the SLP, Your Lordship. The judgment rendered by Your Lordship was not interfered, Your Lordship. And now, Your Lordship, they are circumvented.
Passed in 2023.
Yes, Your Lordship.
The main case.
Yes, Your Lordship. They are trying to circumvent the conviction, actually, Your Lordship, by way of this SLP. Your Lordship, the provision is, in fact, Your Lordship, now they have to invoke the provision of BNSS also, Your Lordship, not the CRPC, because it's already concluded, Your Lordship. Now, Your Lordship, the provision is in BNS section 380, Your Lordship.
I can give this. Yes, yes.
In
BNSS.
actually, they can prepare appeal under 380. They two criminal appeal, not jail appeal, not Your Lordship through the jail authority. They can know if they cannot appoint their own counsel, the convicted person, he can approach the legal aid counsel, but not through jail appeal, Your Lordship. Your Lordship will the provision of jail appeal is in, Your Lordship will find in section 427 of BNSS, Your Lordship, which comes under section chapter, Your Lordship, 31 of the BNSS. And now this order, which is the final order, which they are assailing before this court, is passed under chapter 28 of BNSS, Your Lordship. Their appeal provision is there, but that appeal provision is not in jail appeal, Your Lordship. He has filed an application, criminal misapplication before special court, alleging.
Who drafted this one? This is by the
Legal aid,
counsel.
yes,
Legal
Your Lordship,
counsel.
yes. In fact, it has to be returned back to the, Your Lordship, the registry with a direction to rectify it from the legal service authority, Your Lordship. Because, Your Lordship, it cannot be a jail appeal, Your Lordship, which is reaches finality, attained its finality. Now they are simply challenging the order, rejecting their application under 340 of the CRPC for perjury, Your Lordship. I will not come on the merit because, Your Lordship, otherwise also, Your Lordship, evidence, everything has been appreciated by this Honorable Court, by Honorable Supreme Court. Now, after that, Your Lordship, they are just trying to circumvent the conviction order by way of this application.
Prayer is to admit this appeal, appointed legal aid counsel, then indecent and undergoing trial, so and so set aside the judgment of final special judge. Which is this judgment? 3/12/2024, they have annexed here.
Your Lordship, it's there in the record. Your Lordship will find in the record. If Your Lordship,
Directly done a special judge to consider the by holding a preliminary inquiry. Obviously, it cannot be a jail appeal.
yes, Your Lordship.
But who can you tell us the name? Who is the legal aid counsel in fact?
Yes, Your Lordship.
Legal aid counsel was.
The list of legal aid counsel was there.
No. Someone has filed this one as a legal aid counsel. It was filed by someone.
Your Lordship, normally when
It was because on the prayer from the appellant, whatever. So legal aid counsel was appointed and district legal services appointed. And
yes, yes,
accordingly it was
when the convict person make an application to the jail authority send it to the legal aid team, Your Lordship, and from there they entrust the respective counsel. So then, Your Lordship, they drafted it and they file it before the High Court. But no specific person, a specific legal aid counsel is
no,
entrusted to this.
who drafted this one.
Your Lordship, that cannot be ascertained from the record, Your Lordship. It's simply no
one has
advocation.
appeared today, na? That's what I was. Today, no one is there. Na?
Yes, Your Lordship. This is the issue because, Your Lordship, even initially I was just confused why jail appeal again, because already appeal has been prepared before this court.
They finally.
Yes, Your Lordship.
Try to come for quite a nice. Yeah, no. The one has represented the appellant, though the matter was dealt by the legal aid council, heard Mr. T.A.T., the learned additional PP, appearing for the state respondent, and he accordingly submitted that though it is numbered as a jail appeal, it cannot be a jail appeal, which is filed against and order
1312.
Order passed by
312, yes.
the learned special judge Foxo, dated 3/12/2024, in connection with criminal miscase number 10/2024, filed under section 195, read with section 340 of the CRPC, arising out of Foxo, case number 05/LDV 2021. However, in absence of the legal aid counsel today, no order, as the legal aid counsel is absent today, let the matter be listed. You raise the issue, I'll also see to it.
Yes, Your Lordship.
From here, it cannot be seen now who is the appointed legal aid counsel.
Yes, yes, yes. As on that, no one is appointed. Your Lord, normally they draft it and they file it, Your Lordship, but no specific legal.
No, the jail authority, on the application from the jail authority.
Yes.
It was sent to the district legal service authority, and that was suggested by someone or someone was endorsed.
Yes, yes,
legal aid counsel.
yes, Your Lordship. That we
That's
cannot.
what, that is
Yes, that
not
we
clear.
cannot ascertain from the
Because
record.
no one has appeared also.
Yes, sir.
And name is not there reflected because no one is appearing.
Yes, Your Lordship.
Is the matter on after a week? Let it be matter.
Okay, Your Lordship. Okay.
It's after a week.
Deeply obliged.
It was a case of under section 6 or 4.
Sorry.
Basically,
Your Lordship, it was section 6, Your Lordship.
6 of Fox.
Yes, yes. And imprisonment was for 10 years. And it was upheld by this honorable court, and they went to SLP also. The Supreme Court has not interfered. Deeply obliged.
You don't have to like
Item number 24.
May I please, Lordship? May I please, Lordship? May I please, Lordship?
Yes.
My Lord, on last
Now,
occasion,
order that they demand for
yes, ma'am. CD was called for.
It
Yes,
is,
they-
this
Passing of the FIR.
when your order was communicated to you only. No, as per the office note dated 7/3/25, order dated 5/3/2025 was communicated to you.
Yes,
What
Lordship.
was the order of 5/3?
Lordship, to enable the case diary, Lordship, for scan copy of the case diary.
Scan copy of the case diary was required.
Yes, Lordship. Because this is a quashing of the FIR.
So why it is in order column, in fact?
Lordship, because this case diary was called for, Lordship, on last occasion. Case
But-
diary.
But the scan copy of the case
Yes,
diary.
Lordship.
or
Scan copy of the case diary, yes.
Investigation is still going on.
Yes, Lordship. Investigation.
That has already been received now.
Yes, Lordship, you have received. This is the Lordship, case study, Lordship. This is the case. It is pending for the MBI, this motor vehicle inspection report. For that only it is pending. Otherwise, Lordship, the statement already been recorded of all the.
So you are challenging or the FIR itself?
Yes, my Lord.
For quashing of the FIR?
Quashing of offense upon compromise between the parties.
Huh?
Upon compromise between the parties.
Acha.
On compromise.
Matter has already been compromised.
Compromise. My Lord, if
Okay,
Lordship
then,
permit, my Lord, it
is
can
an
be.
order from, I'm not going to hear any matter.
Yes, ma'am.
I
Let it
have-
be not fixed for admission hearing, my Lord.
That can be done.
Yes.
I heard Mr.
H. Lampu.
H. Lampu, the learned counsel for the petition, also heard Ms. Al Hage, the learned additional PP. She submitted accordingly that scanned copy of the case diary has already been received, and from which it is seen that the investigation is pending only for the receipt of the MBI report. Let the matter be accordingly listed for admission hearing on after a week will do, after 1 week or after 2 weeks.
Let it be on my lord, 17th.
The 17 will also matter 7 weeks. 17 is not possible.
Let it be on my
It
lord.
will be after 1 week, then it will be listed also. I don't know.
Next week, any date next week.
Any date next week?
Let it be on 19 month.
19.
19.
You want a fixed date?
Yes, ma'am.
19. Okay, we are listing it on 19. It will be listed in the admission column and that may be disposed of on that.
Your Lordship, in item number 20, Your Lordship.
20.
20. There was an interim, Your Lordship. If Your Lordship.
In 20.
20.
20 we have taken. Interim be continued till next date of listing.
Deeply.
Now there are 3 hearing matters are there. 1 CRP, 1 criminal appeal and 2 CRPs.
So in the item 24, we have to retain the scan copy of the case diary.
Which one? Item
24, Lordship.
The order which have already.
Yes, Lordship.
You can, because it is a other also it is a scan copy.
Yes,
So
Lordship.
it can be written.
Lordship.
And the as per his submission, the matter has already been settled, only compromise.
Yes.
So go through it and it may be disposed of also. I don't have as a personal actually difficulty. That's why I'm not taking the. Otherwise, it can be a matter of disposal effect. Others will have to your proper. So very well. CRP 27. So are you ready for hearing?
Your Lordship.
Huh?
Yes, Your Lordship.
You are for the petitioner.
Petitioner, Your Lordship.
And other side? You are for the other side.
Mr. Counsel.
My some personal inconvenience is on my part. So I'm not going to hurt the matter today. So it's a matter of 2020. So let it be listed after 1 week or 2 weeks we need. After?
After 3 weeks, Your Lordship.
After?
3 weeks.
After 3 weeks?
2 weeks, 2 weeks.
2 weeks, let it be after 2 weeks. Due to positive for everybody. After 2 weeks, it will be listed for hearing. Twenty-eight is the jail appeal.
28, yes, jail appeal.
It's an also amicus is appointed. Oh,
Yes.
it's not available, I think.
Not available.
Since when he is in custody, in fact?
Lordship.
Since when he is in jail?
Jail, Lordship.
Because
order,
jail
Lordship.
appeal is of 2020, most probably
Yes,
more
Lordship.
than 1 year or 2 years, most probably.
It's a 3 years punishment, Lordship.
Pardon? 20?
3 years punishment, 3
3
years.
years punishment.
Yes, section 8 of OXO.
Yes,
Yes.
he is already on jail till
2022.
2022.
Yes, Lordship.
Then too, it is.
You need to be heard early, actually.
Huh?
It need to be heard early because this is the last year, Lordship, till September only.
Because 3 years punishment, already in jail around 2 years. So half of the more than half of the punishment he is in jail, na? Due to absence of the learned amicus curiae appointed for the appellant, the matter could not be heard. Matter could not be heard. So it will be listed after 1 week, and we made an observation that endeavor shall be made. List the matter accordingly after 1 week. And endeavor shall be made to hear and dispose of the matter. Hear and dispose of the matter. List accordingly. Yes. No, no, have water, some water. Sorry, I'm not going to hear any matter. Actually, 2, 3 matters are from this bench also I have to dictate. And some of the matters are there. So you just take a date.
I am tasked to draft the proposed advocate amendment bill by the Bar Council. For this, which is your date after 20 any day?
27 of this month. I'm outstation lawyer.
Outstation
lawyer.
You are outstation. From where you have come?
27 is Thursday.
Hello.
Hello.
Thank you. Fine, my love, because this is in 20, I'm busy drafting that. The government has come out with the amendment in the advocate bill, and there is hue and cry in the nation. All the president of the Bar Association are tasked to draft it.
Okay, okay.
So I have been made as chairman of that committee.
Okay, very nice.
Yeah, but this interim order may be extended. Endeavors shall be made for disposal on 27.
27 can be fixed. Huh?
There is convenient date.
27 corridor. Interim be continued till instead of listing and endeavor shall be made to hear and dispose of the matter.
Whenever outstation advocate comes, I always try to accommodate that.
No, obviously, it is our duty, in fact. But I thought that he is from here only. Anyway, you are from Arunachal, not from the out when they other from the other.
No, Milad. Actually, he is practicing here, but he is not aborigine of my state. He is from Assam, probably.
Oh, he is from Assam.
No,
No, he said that he is from Alu.
No, Your Honor, I am staying here at Alo. I'm practicing there.
No, that's why.
Alo and Basa.
Alu and Basa.
Basically.
So otherwise you are staying in Arunachal, the state of Arunachal. But you are from, basically you are from Assam.
No, I'm from Bihar.
Acha, Bihar.
Okay, that is it. That's
He is saying that he is from Assam.
not of origin of my state. Mohammed Ansari.
And do some work, okay.
Grateful.
Vanessa, 20 को हमने क्या किया? 20 का ना? हाँ, 24 का तो 19 बोला क्या? 29 का क्या बोला आपने बात का? 24 का 19 बोला है ना बेटा? मेरे को पूछने दे